everyone, and we are here with Bernadette Sargeant of the Stinson Law Firm. We are talking about one of our panels at this year's DC Bar Changing Currents in Employment Law on October 29th of 2019. And Bernadette, your panel is going to be on medical marijuana in the workplace. So let's talk about medical marijuana, because when we're dealing with that subject, I mean, it's a really complicated subject because you've got kind of differences between federal law and state law and local law. So what's an employer to do?
Scott, it's a minefield, really. I think the bottom line is employers, even in states where there are comprehensive medical marijuana laws, the federal law, marijuana is still a controlled substance. And a lot of employers, they might have positions that are safety requirements. So employers still have a lot of discretion if they want to be able to discipline or terminate an employee who has a positive marijuana test result. Impairment is a separate thing. Impairment is always cause for termination, even for a legal substance like alcohol. But here are the complications. First of all, not every employer wants to terminate his or her employees.
Maybe their best, like their best employee.
That's right. But if you're a federal contractor, you pretty much have to, if you're doing contracts that require your employees to have any kind of security clearance, if they have to have a drug-free environment, if they have to be able to pass drug tests. And we've gotten more than one call from clients who are federal contractors who are beside themselves because one of their best employees on a contract now has this marijuana issue. Medical marijuana obviously is different from recreational marijuana. States that allow medical marijuana usage, they usually have a lot of certification requirements, prescription requirements. But even if an employee goes through and has all of that certification that they can present, the federal law still stands as a potential roadblock.
So, I mean, let's say that I'm an employer or counsel for an employer. I'm sitting in the audience at Changing Currents on October 29th. What am I likely to hear in terms of the advice that you would give me in kind of crafting a marijuana policy in my workplace?
Well, I think if you're in a position where part of your practice is counseling employers, you always know, step one, listen to all the facts and circumstances of your client's situation. So, if your client is doing business in DC, there is, as I said, a comprehensive medical marijuana statutory system, but there's still the federal prohibition. A lot of our DC employers are federal contractors.
And I'm a federal contractor. I'm following federal law.
Right. You have to be able to follow the requirements of your contract with the federal government. So the issues become, do I have to, for medical marijuana, do I have to accommodate? If a person requests an accommodation, do I have to accommodate? I think the short answer right now is that if you're a federal contractor, you probably don't have that option. If you're not a federal contractor, if you're a private employer, or if you have contracts that are not for the federal government, it's probably more nuanced whether you need to engage with some interchange as to accommodation.
So for an employee then, I mean, what's some good advice from the employee side? You're going to have a co-panelist on your panel.
Right. My co-panelist is going to be Roshni Shikari of the Correia Puth PLLC law firm. They do employee side. We're working collaboratively on our presentation. From the employee's side, the advice I would give them is, first of all, if you work on a federal contract, you need to talk with your medical provider about some alternative treatments because you're probably not going to be able to get workplace protection for medical marijuana use. If that's not an issue, if you don't work in a federal contracting situation, if you have been through the certification process for medical marijuana, you have whatever approvals and your doctor's prescription and so forth, you should proactively raise it. If you work for an employer with a drug testing policy, you should communicate with HR and go through that accommodation process.
Just like in any ADA case, I've got an obligation to let my employer know.
Right, if you're going to need an accommodation.
Bernadette, thank you.
Oh, you're welcome.
And we look forward to seeing you on October 29th of 2019 from 6 to 9:15 p.m. at the DC Bar headquarters, changing currents in employment.